Hello friends, in the series on the income tax cases, today we will discuss the issue of retraction of statement which is taken by the revenue authorities either at the time of the survey proceedings or at the time of the search proceedings. When there is search on the assessee, the statement which is taken from the assessee under section 131 is taken on oath, but at the time of survey the statement is not on oath. So the evidentiary value of the statement which is in the case of search is more than that in the case of survey. It is generally seen that when the department comes at the place of the assessee is under duress, there is some pressure on the assessee. When the statement is being given by the assessee, it may happen that the assessee may not be aware of the facts properly and he may give a wrong statement or the statement which is inflated one. So the assessee has every right to retract his statement, whether in full or whether in partial. But the theory of retracting the statement is that the period between giving the statement and the period when the statement is retracted should be very less. And when this statement is retracted, what the stand the assessing officer should take, this issue has been taken by the Chandigarh ITAT A bench in the case of Lachhman Bansal versus Deputy Commissioner of Income Tax. This case has been reported in 110 ITR Tribunal at page number 439 and the date of the judgment is 12th January 2024. In the present case, there was a survey under section 133A on a senior citizen, and in that survey the statement was taken regarding some cash credits, advances, and there was also difference in the actual stock which was there and the stock which was there in the books. After 2 weeks, the assessee, which was a senior citizen, retracted the statement with proper affidavits and with facts that whatever the assessee has stated in the statement are not correct. So he withdrew his statement. But when the assessment was going on, the assessing officer summarily rejected the retraction of the statement without rebutting the retraction of the statement. When the matter was before the CIT appeal gave some partial relief to the assessee, and as far as the shortage of goods which were actually there in the stock, the physical stock was less than the stock which was there in the books. So in that case the CIT appeal treated this shortage of the stock as sale of the assessee and calculated the gross profit on that sale at the rate of 8.02%, which was also upheld by the tribunal. As far as the advances were concerned, it was the viewpoint of the tribunal that the assessing officer has erred in rejecting the retraction of the statement summarily when the assessee is a senior citizen, when the statement has been retracted before the show cause notice, and when the statement has been given under duress, then the assessee has every right to retract the statement with proper facts and circumstances. So as far as the advances were concerned, the tribunal said that the diary or the loose papers which the assessing officer was relying on was only mentioning the names and some amounts against them, but even the year of the transaction was not there. It was not mentioned in that loose sheets that whether the amount is received by the assessee or paid by the assessee. The assessing officer does not take any heed to make any inquiry about those persons, and there was no supporting document supporting the transactions which were there in the diary. So in that circumstances, that loose diary and sheets can be treated only as dumb documents and cannot be relied upon for making the additions for the assessee. But as far as the unexplained cash credits were concerned, the tribunal was not satisfied with the retraction of the statement to that particular part and upheld the additions. So friends, from this case it is very much lucid that whenever the retraction is made, it should not be made in a very easy manner. It should be supported by documents, facts. It should be retracted within a very less time, not more than 2 weeks or 3 weeks, and it should be addressed to the higher authorities of the revenue. At the end of this video, once again I am repeating the name of the case. The name of the case is Lachhman Bansal versus Deputy Commissioner of Income Tax, and this case has been reported in 110 ITR Tribunal at page number 439. The matter has been decided by Honorable ITAT Chandigarh A bench, and the date of the judgment is 12th January 2024. Thank you friends.